So thanks for coming to Love and Responsibility Winter. We're very excited tonight to have Ed Mechmann, who's the Director of the Public Policy Office and Safe Environment Office. He's going to be giving a very important talk on the Equality Act tonight. Ed's a really good friend of our young adult office, and he's pretty much my go-to for many things, especially with issues like this. And we just welcome everybody who is watching on Catholic NYC, and welcome everybody who's watching on Clubhouse as well. And so without further ado, I'll give it over to Ed. Please welcome him.
Okay, thanks everybody. Thanks for coming out on a night like this. Thanks to the guys who are watching me wherever the heck in the world you are. This is a very difficult subject to talk about. And it's a difficult talk for me to give. This subject, particularly about gender theory, gender ideology, is a bit of a third rail in American discourse right now. It's very hard for people to speak about it because very many people are very, very sensitive about it. It's actually at a point, I think, to a certain extent where rational conversation about this subject is just not possible. American politics is at such a place where it's just really difficult to talk about subjects like this. Yet, I'm sure that you are hearing from people, you're seeing things on the news, you may be experiencing some of this issue in your workplace or in your families. It's something that we need to be able to speak about so that people understand, first of all, where the church stands on the issue of gender theory and discrimination and things like that in general, and then also particularly to talk about this bill, the Equality Act, which is H.R. 5, House of Representatives, Bill number 5. This is an issue, if this bill passes, that's going to have a direct and immediate effect on every single one of us. It may not seem that way at first, but I hope you'll see how it happens after I've finished speaking. You know, our church has taught for many years about issues surrounding gender and sexual orientation and things like that. You know, none of us want to discriminate against people. None of us want to hurt people's feelings. We want to make sure that we treat people with love and with charity and treat them kindly. That's the golden rule. Our church forbids us to engage in any kind of unjust discrimination against people. So it's a subject that we have to kind of walk a little bit of a fine line so that we understand where we stand, why we stand there, what the lines are that we don't want the government to cross into our sphere of freedom, while at the same time still respecting people who are on the other side and still loving them as best that we can. So I've got a little bit of a plan of action here. I want to talk about a number of different subjects. I'm a lawyer. I'm sorry. I'm going to take you into lawyer land a little bit. I even wore my lawyer suit tonight just to show that. It's pinstriped. You can't see it, but it is. I'm going to talk very briefly about gender ideology or gender theory. I'm not going to focus too much on sexual orientation here tonight. It's a factor in the bills, but I think gender theory is much more important and significant for the way the bill works and how it will affect us. I want to talk about that first, and I'm going to give you an idea of how civil rights laws work, because it's very important that we understand the mechanism by which this legislation might work. Civil rights laws are complicated, but I'm going to try to make it clear to you how they actually work. And then I'm going to speak about the three major problems that I see in the Equality Act. First, its vast reach, which is really unprecedented in American history, problems of religious liberty, and threats to human life. So that's the basic plan. So let me talk a little bit about gender theory or gender ideology. I tend to use those terms just interchangeably. The Equality Act incorporates an idea of gender identity. It would incorporate in all of the major federal civil rights acts a ban on discrimination on the basis of sexual orientation and gender identity. Now, it does it in a funny way because it puts those two words as if they are a definition of the word sex, which already appears in federal civil rights laws. It's been in those laws since 1964, the Great Civil Rights Act of 1964. No one, of course, would ever in their right minds have thought back in 1964 or 1978 or 1974 when the statutes were changed that the word sex would ever mean sexual orientation or gender identity. In fact, until the Supreme Court rewrote that word last year, even the advocates for non-discrimination didn't think it did that because they were still trying to pass this bill, and they still are trying to pass this bill. So there's a problem with that concept, gender identity. Let me tell you how the Equality Act actually defines it. It's actually in the statute itself. It says the term gender identity means the gender-related identity, appearance, mannerisms, or other gender-related characteristics of an individual, regardless of the individual's designated sex at birth. Wow, that's a bit of a strange definition to me because it is very, very murky. What are they talking about? Other gender-related characteristics of gender-related identity. What does that even mean? Well, if you look elsewhere in the law, you can get a sense of what the advocates for these bills think it means. New York City has a human rights law, which is basically a civil rights law, and they have a ban on gender discrimination. And here's how New York City's bill, city's law, defines gender identity. A person's gender identity may be male, female, neither, or both. That is, non-binary or genderqueer. Gender identity is not the same as sexual orientation or gender expression. Terms associated with gender identity include, but are not limited to, agender, bigender, butch, female, woman, feminine, feminine to male, FTM, femme, F-E-M-M-E, gender diverse, gender fluid, gender queer, male, man, masculine, male, female, MTF, man of trans experience, pangender, or woman of trans experience. Good luck. I have no idea what half of those things are, 3/4 of those things are. The thing that gets me concerned as a lawyer, because you always worry about a law. The law's got to be clear, right? It's got to tell you what the law is, what you can do and what you can't do. It has to make sense. It's not the same as gender expression. Gender expression is how someone presents themselves. So if your gender identity isn't the same as your gender expression, how in the world am I supposed to know what your gender identity is? And how in the world am I supposed to know whether I'm discriminating against you or not if it's a characteristic I can't even see, much less understand? All the other characteristics that are in civil rights laws are fairly clear and easy to understand. Race, sex, well, nowadays, who knows? National origin, veteran status, religion, age, I say age, national origin, things like that. They're all things that are fairly clearly understood. This one, not so much. And I think a lot of people don't really, haven't been following public discourse in the last 10 years or so, just have no idea where this even comes from. What are you even talking about? Those of you who have gone to college or university in the last 15 or 20 years, of course, know this well because it's starting to permeate college curricula and the way that things are taught in colleges. It's the idea basically is that gender, this concept called gender, is not determined by your biological sex. In fact, your biological sex is kind of irrelevant to your gender. Gender is something instead that you define for yourself. It may or may not be related to your biological sex. It could be any one of those things on that laundry list I just read. Your sex instead is an arbitrary classification that's assigned to you at birth. You know, you pop out the birth canal, the doctor looks at you, I'm going to assign maleness to this baby, or femaleness to this baby. Let me tell you, I've been present at the birth of my 3 children. It's pretty bloody obvious, literally bloody obvious, what sex they are. Okay, we're not just assigning it to them, we're looking at it. But the idea of gender is it's an outgrowth of a very powerful trend in American thinking of radical autonomy. The idea that I can define myself, I can define sort of the meaning of life and the universe, all those things, and it's a particularly broad application of that. The problem is, of course, that this flies in the face of science. Science has established pretty clearly, without any question, that sex is a biological characteristic that defines us down almost to the molecular level. It determines not just our physical characteristics, but also the way we think, the way we feel, It's funny, there was an article in the New York Times, which is one of the great advocates for gender theory. There was an article, I think it was today, about how men and women, male biological men, biological women, respond differently to the COVID vaccine, that we have different side effects. And it goes down to our basic biology. So it's funny, you wonder sometimes if the people on the opinion pages read the guys who are writing in the science section. And you know, even if you're in college, if you were to go down the hallway from the gender studies department to the biology department and start talking about this stuff, they would throw you out because the science just doesn't make any sense. As Catholics, we also have another source of knowledge, and that's divine revelation. We believe it's been revealed to us in the book of Genesis and throughout the Bible. God made us in his own image and likeness. Our maleness and femaleness is a fundamental component of who we are. It's a direct expression of God's will. God willed that I be a man at the moment of my conception. God willed that my wife be a woman at the moment of her conception. I will be a man throughout my earthly life, into my heavenly life, and then into the next life in the New Jerusalem, the new creation. This is something that the church has always held to. No one challenged it for centuries, so it wasn't really talked about for a long time. But ever since the challenge has arisen in the last, again, 15, 20 years, the church has been very strong in reaffirming always that gender is maybe an expression of my identity or expression of my personality, but it does not deny the reality of maleness and femaleness. This is a fundamental component of what we believe about the human person, made in the image and likeness of God. It's not something that we can compromise on. This is what God has revealed to us. I was at a government office one time discussing this matter with a public official, and I had to stop every few minutes and remind them, you know, we're Christians, we actually believe in the male-female thing, right? That God made us this way, okay? Because they weren't seeing it. I had to remind them of that every so often. So why does this matter so much to us? I think it's funny, you know, we are here from a position of faith. Gender ideology has become kind of a secular religion in a way. Heresy and dissent from it are not tolerated. But it's important for us, I'm going to put my lawyer hat on again, it's important to us because, again, for a law to be valid, it has to be clear, it has to make sense, it has to be understandable by regular people, not just lawyers, about what's forbidden and what's permitted and what's required. The laws involving gender identity fail that test because they fail the test of rationality and they fail the test of understandability. We don't know what the heck this means. And that is a very significant problem because when you have ambiguous laws, they can be used punitively, they can be used discriminatorily, and they can be used to punish one's enemies. Sort of like when you're in school and all of a sudden the teachers remembered a rule that they had never enforced before, but that's somewhere in the student handbook, and because that you get detention. That's the problem with ambiguous rules. That's dangerous. So that's one of the major things that we worry about. If I can't see it, and if it can change at any time, how can I even know what I can do and what I can't do? Now, that's the basic quick overview of gender theory, gender ideology. Let me talk now a little bit about how civil rights laws work, because this is really important to understand to see how this is going to have an effect. The federal government has a number of civil rights laws, so do the states. I'm not going to talk really about state laws, I'm really just going to talk about federal laws right now, because that's what the Equality Act is. For a civil rights law to work, the government has to have authority over you, and you have to have hurt somebody in a particular way, okay? Very simple. They have to have authority over you, and you have to have hurt someone in a particular way. Let's talk about authority. The federal government has always been a government of limited authority. That's the Constitution. Most of the authority about matters are left to the states. That's the way it was written throughout most of our history. That's the way people understood the Constitution. The federal government is limited. The state governments are really the ones that operate in most ways. Well, not so much anymore. For the last century, since the New Deal, federal authority has been expanding vastly. It's largely because of an interpretation of a clause called the Commerce Clause. Anything that affects interstate commerce is within federal jurisdiction. Well, almost everything we do nowadays affects interstate commerce. All of us are wearing clothing. I'd be willing to bet that not a single article of clothing in this room was actually made in New York State. I'd be willing to bet that everything was transported in interstate commerce or international commerce. Our phones, a lot of our clothing made in China and other places, right? Everything. Anything that travels in interstate commerce gives the federal government authority to regulate and pass laws. There's another phrase in the Constitution. It's usually called the spending clause. It says that Congress can promote the general welfare, and that's how they spend money, right? They spend money. They passed just a $1.9 trillion bill today or yesterday, right, to promote the general welfare. It's the spending clause. Any dollar that comes from the federal government can have strings attached to it, right? And anybody who receives a dollar from the federal government is subject to regulation by the federal government. So that's how widely this goes. The laws and regulations that are coming out of the federal government affect almost every aspect of our lives. Usually we don't even notice it. You guys all went to colleges. Every college gets federal aid. They get your student loans. That brings the federal government in. Every workplace that we have, the EEOC, Equal Employment Opportunity Commission, and OSHA, the Occupational Safe and Healthy Administration, regulate your workplace. You know, somewhere in your workplace they have the gigantic poster up there of all the different rights and regulations and all that kind of stuff. Half of that is federal. That's how far they go. Your bank transactions, your financial transactions, your phone, your health care, just about everything is subject now to federal regulation. And when I say regulation, it's important that you remember that word. The Equality Act is in Congress. It's a bill that they want to make an act of Congress, a law, a statute. Most of the laws in the United States aren't passed by Congress. They come from administrative agencies. They're regulations, they're guidances. The president signs executive orders. These never go through Congress, and yet they have a massive effect on our lives. Usually the statute is very broad that Congress passes. The regulations drill down into tiny details. We are always subject to these regulations. And one of the things you notice, there was just a change of administration, right? All the old executive orders, they've been revoked. New executive orders come in. So there's new rules on January 20th. A lot of the regulations that were in place in the old administration, they were put on hold and they'll be revoked by the new administration. It goes back and forth from administration to administration, which adds another whole element here. How do we know what the law is if it's going to change in 3 months, depending on who wins the election? So I can't emphasize this enough. We are so much at the mercy of these rule makers in government agencies, mostly lawyers, right? They all have hundreds of lawyers, and they're sitting around, and what else do they have to do except write regulations, right? That way they can make sure people think that they actually have a phony baloney job that matters. Okay, so that's authority. Believe me, the federal government has tremendous authority over us. The second question is, are you injured in a particular way? Now, discrimination is a dirty word, right? No one wants to be a discriminator. No one wants to be discriminated against, right? Discrimination is not the same thing as just being treated differently, okay? We can treat people differently. That's not necessarily discrimination, okay? Discrimination is when that different treatment treats you worse than the other person, treats you badly because of a characteristic that you have. And those are the characteristics that are contained in the law: age, sex, race, things like that. You're treated worse because of your race or because of your age. For example, I'm an older person. I'm treating you badly right now because of your age. You're all younger than me, and I'm speaking to you and putting you through all this stuff, right? So I'm discriminating against you because of age. In fact, yeah, don't worry. So it has to be bad treatment in a particular place. Your work, employment, health care, what's called public accommodations. Remember this word because it's super important. Public accommodations, you know, in the old days of Jim Crow, right? I don't know if you saw the movie The Green Book. I think it was called, yeah. The Green Book, they're traveling around, it's an African-American fellow being driven by a white guy, and blacks can't stay in certain hotels, they can't eat in certain restaurants, they can't go to movie theaters, things like that. That's a public accommodation, a place that's open to the public to come in and be, just watch a movie or eat a meal or something like that. That's always been the hallmark, actually, of most civil rights laws. They go at public accommodations because that's where a lot of the really denigrating, nasty stuff was done, especially to blacks, but also to people of other national origins and so forth. They were put, the colored sign, right? Whites, coloreds, which still are present. You can still see those horrible signs, places, the different entrance, all that stuff. So that's where the government comes in. In one of these particular areas, public accommodations, education, and public schools, say, employment, if you're treated badly in one of those places because of one of those characteristics, then you're discriminated against, and you can go back to the government and get redress. Now, there are some exceptions. There's always exceptions. The different treatment has to be unjustifiable. The classic example is race. There's almost no example of a case where a racial difference is justifiable under the law. I was trying to think of one today. The only one I could think of was, there's a concept called Bona Fide Occupational Qualification. And I was thinking, well, what about like a historic black college? They want to hire a mentor for the students. I think that's perfectly reasonable to say we're only going to hire a black person. That's a bona fide occupational qualification. We do this all the time in the church, right? We hire Catholics. That's a bona fide occupational qualification, but we're discriminating against Lutherans and Presbyterians and all sorts of other wonderful people who are just not Catholic. So it's a little bit complicated, right? The government has to have authority over you. You have to be treated badly because of a characteristic in a particular place, and there can't be a justification for it. Okay, that's my real dip into lawyer world. I'm sorry that didn't take too long and bored the heck out of me in law school, but anyway, that's where we are. So let's talk now specifically more about what happens with the Equality Act. The Equality Act basically amends every single one of these civil rights laws that are in the federal code. And it adds sexual orientation and gender identity into the characteristic of sex, okay? But what it also does is something that is extraordinary and really unprecedented in the history of the United States. It takes the term public accommodation and it expands it so far that it includes basically everything. Again, traditionally public accommodations were hotels, restaurants, bars, bus services, planes, things like that, public accommodations. The Equality Act expands that to include, and this is a direct quote from the bill, any establishment that provides a good service or program. Any establishment that provides a good service or program. Any. Doesn't have to be open to, just as long as it's giving something to the public. And the word establishment is defined to include an individual whose operations affect commerce and who is a provider of good service or program. You don't even have to own a store, right? You are all, if any of you are in any kind of service work, if you're an independent contractor, if you're a freelancer, you are all public accommodations under the Equality Act. A cleaning lady who has a little cleaning business that goes around to people's houses, right? She doesn't have an office, she doesn't have a building, she's a public accommodation. If you're sitting on your couch coding, right, for some, multi-gigantic corporation that's selling stuff to people, you don't have an office, you're still providing a service to the public, the company. You're a freelance writer, sitting, writing technical manuals or something. You're a public accommodation. This reaches into your living room, potentially. Every professional, every doctor, every dentist, every chiropractor, every lawyer, everybody, everything, a massage therapist who brings her table around to your house. Public accommodation. So this bill would reach basically every business, every organization, every individual who does anything for the public, which is pretty much, I think, everybody, almost. It's kind of hard to figure out anybody who's not included in that definition. And from the church's perspective, of course, this also includes our churches, our schools, our charities agencies, our hospitals, our nursing homes, all those things too. Again, all of us, this is a school, right? This school will be a public accommodation under the Equality Act. Even though it has limited admission, it has, selectivity of admission, because everything they do is service to the public. And they, of course, have stuff here that's traveled in interstate commerce. I'm sure the chalk has traveled in interstate commerce. So every single institution. The Equality Act also amends the part of the law that attaches conditions to federal funding. Now, I don't know if you realize how ubiquitous federal money is, but every school, every hospital, every social service agency, almost every business gets federal money of some kind or another. Under these COVID relief bills, think of how many businesses got the payroll protection program. That's federal money. They're recipients of federal aid. The Equality Act would apply to them. Even if they weren't public accommodations, it applies to them. It's kind of a funny thing. Any of you get federally guaranteed student loans? Yeah, you're a recipient of federal aid. You're covered by the bill. Again, how does this play out, though, for real people? I'm not just talking about big institutions like the church institutions. I'm talking about every one of us at our work, right? Because every one of us, if we're employed at a place that serves the public, the Equality Act will incorporate gender theory and gender ideology into all of your HR training, all the business's activities. If they're going to do, a St. Patrick's Day event, they can't discriminate against the Transgender Day event, right? And how many people start to feel pressured then in businesses? You hear it all the time. I'm under pressure. They want me to declare myself an ally. They want me to wear the button. I'm afraid of saying anything because I'm afraid of being accused of creating a hostile environment. This is one of the areas that the civil rights laws really have punch. The whole idea of a hostile environment came out of sexual harassment, which, by the way, that law does still apply in the governor's mansion, just in case anybody's wondering. But it's a great thing because you don't want anybody to have a hostile environment. Well, what will it take to make the environment hostile? If I am talking to Colin at our workplace, and I say, I'm really not too keen on this whole, gender thing. I think a man's a man, a woman's a woman, and someone hears me say that could be a hostile environment. I could be sued. I could be fired for saying that. The business could be sued. Right? So you see how this can affect even our individual conversations. By the way, that's not a myth. The law books, the court books are full of cases of people telling dirty jokes in the workplace and someone overhearing them and suing the business because it's a hostile environment, which it is in many cases, if it's really egregious. So this is a very serious threat, I think, to everybody. It will force people to shut up about our religious beliefs. It will stigmatize our religious beliefs in school, at work, when we go for our health care, wherever we are. It will stigmatize us as bigots and haters and discriminators. Even though I work for the church and there's a huge impact on us, it also has an impact on every single one of you people who are here and the people who are off in the virtual world listening to me. Usually when these kinds of laws pass, we have one in the city, we have one in the state, there's some kind of religious exemption or defense to these things. That's how we're able to live with them mostly. New York State has a law, New York City has a law. The church has been able to live with them. A lot of religious people have been able to live with them because New York State actually has reasonably decent religious liberty protection in our statutes. The Equality Act, though, has a provision that is just astonishing to me as an attorney because it is specifically designed to take away the civil rights of a group of people. It is the only case that I can think of in the history of the United States where an act of Congress would take away people's civil rights by statute. Because there's a provision in the bill that says the Religious Freedom Restoration Act is no defense, can't be used to defend yourself against any claim affected by this bill. In fact, affected by any of the federal civil rights laws. Well, what's the Religious Freedom Restoration Act? That was a bill that was passed by unanimous consent, basically, in the United States Congress, signed by Bill Clinton, of all people, saying that if the government imposes a burden on your religious beliefs or practices, the government has the obligation of justifying that by showing that they've got a really significant reason and they can't accomplish that reason by any other way. That's basically what the Religious Freedom Restoration Act says. So this is a very important bill. It actually applies to religion the same basic constitutional standard that applies to any of our rights. Free speech, your free speech can't be eliminated unless the government has a very substantial reason and it's a very narrowly tailored law. It just puts us on an even par, our religious beliefs, on an even par with pretty much every other constitutional right. And you remember that freedom of religion is actually mentioned in the Constitution, right? You remember that in the First Amendment? Gender does not appear there. I think the Founding Fathers would be stunned if they even heard us talking about this stuff. So what the Equality Act would do is basically it would take away our ability to assert our religion as a defense in a situation where we have discriminated against someone or when we're being accused of that. Takes away a defense, which is funny. It's called the Equality Act, but it makes us very unequal. Right? We're now second-class citizens. And none of these situations in employment or hostile environment situations, our health insurance plans won't be able to say we won't cover transgender things because they're against our religious belief. We can't assert the religious freedom restoration for that. These wedding vendors who don't want to bake cakes or take photographs or make flowers for gay weddings, they won't be able to defend themselves. Solo practitioners or freelancers won't be able to turn down work, for example. I'm thinking, for example, of my sister-in-law. She's a marriage counselor. She doesn't want to service same-sex couples. That's part of her religious beliefs. She doesn't want to do that. Won't be able to. She's a public accommodation. She could be sued. Our doctors will all be forced either to do or refer people for gender reassignment surgery, which is a fancy word for mutilating surgery on our bodies. They won't be able to refuse. Our hospitals will be in the same situation. Our hospitals won't be able to refuse that. We'll have to either do it or refer. Our foster care agencies are under direct attack. We know that some foster agencies, care agencies, have closed down rather than place kids with same-sex couples, for example. It's a case before the Supreme Court right now over that issue. Homeless shelters won't be able to sex segregate. Prisons won't be able to sex segregate. Domestic violence shelters won't be able to exclude men who are presenting themselves as women. That's how far it goes. And that, again, that's not a horror story. We in the church have already dealt with an issue involving homeless shelters where we were being forced to not just house people in the opposite sex environment, but train everybody that this is okay. Because that's the other part of what happens here. When it's a non-discrimination thing, right, it will force people to say things that they don't believe. It will force words out of the mouth of every HR director who has a religious objection to the idea that there's no such thing as man and women. Every single one of them. It'll force them to speak. One of the hallmark principles of freedom is that the government should not be able to make me say things that are contrary to my belief. Some of the greatest Supreme Court cases have involved this very issue. The Jehovah's Witnesses who don't want to pledge allegiance to the flag because they think it's idolatry. The people who don't want to serve in the military because they don't want to support wars. Things like that. Our case law is filled with these situations. Making Jewish people work on the Sabbath. Making them sell pork. Making Muslim or Jewish prisoners eat pork. Or non-kosher, non-halal food in the prisons. There was a case that went up to the Supreme Court. I mean, you can see I get exercised about this because I just find this so outrageous that there would be so little respect for our ability to live according to our faith, to speak according to our faith. And again, this doesn't just affect institutions, it affects individuals in the workplace. People will not be able to speak or make decisions based on their religious beliefs. The Equality Act is not about equality. It's about turning us into losers. we lose every battle. And that's going to cause just perpetual conflict. And it will also create pressure on people to conform. It'll put pressure on people to shut up and go along. Just keep quiet for 4 years and get your diploma, right? Just turn the other way so I don't lose my job, things like that. Over something that goes to the very core of who we are, our faith, and also our maleness and femaleness. So that's the religious liberty problem in the Equality Act. There's also a problem of a danger to human life. Obviously abortion is an issue that has roiled our politics and law forever. The Equality Act has a very innocent sounding provision in it that would ban discrimination based on pregnancy or pregnancy-related conditions. Now, there's already a law that, since 1978, that bans that. So what's the big deal with this? Here's the problem. In the other bill, the Pregnancy Discrimination Act, there was a specific exclusion of abortion. Right? So this doesn't cover abortion. No employer is going to have to cover abortion in their health insurance. Right? There's other federal defenses for doctors and so forth from participating in abortions. But this was aimed directly at employers. That clause is not present in the Equality Act. They omitted it. And they omitted it for a reason, and that's because pregnancy-related condition has been interpreted by some agencies, the EEOC, for example, as meaning abortion. That you have to treat abortion the same way you treat any other condition. So just as every doctor who does, say, mastectomies will also have to do gender reassignment surgeries, every doctor who delivers babies will have to perform abortions or refer for them. Every hospital, same thing. Every nurse, every midwife, which is unbelievable to me that a midwife would be forced to cooperate with abortion. There's no question that this is going to advance. As I said, the EEOC has already held that in a limited capacity. The current administration absolutely is going to push this in the EEOC, either by regulation or by statute. And this vastly expands the number of people who will be forced to cooperate with an operation that is, to us, a heinous crime. It's the direct killing of an innocent human life. All of our charities agencies will be forced to refer. Every social worker, every doctor, every nurse will be forced to refer. Every school counselor will be forced to refer. Our hospitals won't be able to refuse. Our schools won't be able to hold back. They'll have to refer people. Every professional will have to refer people if people ask them. Anyone in those businesses will have to cooperate. Even, and this is what's amazing to me, crisis pregnancy centers that deal with women who are in a crisis pregnancy and want to help them not have the abortion, even they will be covered by this law because they're public accommodations. Can you imagine it? The law forcing a crisis pregnancy center. The Sisters of Life will force them to refer people for abortions. The Sisters Ministry to moms in crisis is absolutely a public accommodation under this law. Can you imagine the Sisters of Life having to take people to Planned Parenthood? I mean, it's obscene. So what do we do? I mean, what can we do about this? Especially us as little individuals. The bill is a direct threat to religious liberty. It won't go away. It's already passed the House. It probably won't pass the Senate because to pass anything in the Senate, you have to get 60 votes to kill the filibuster. As of right now, that rule will probably be gotten rid of soon because the progressive wing of the Democratic Party hates it because it stops them from passing a lot of stuff they like minimum wage laws and things like that. The days of the filibuster, I mean, that's on life support. Once that goes, all you need is 50 votes, 50 plus 1, to pass a bill in the Senate. They don't have 60 now, but they have 50 plus 1, I think, probably. So if the filibuster goes, the Equality Act passes, the president will sign it, and we're going to have to come up with some way of living with it. What does that mean? Assume for a second that this law passes. What do we do? How do we deal with this? We as Christians are going to have a lot of work to do because we're going to have a lot of thinking to do. How will this affect our church in its ability to preach the gospel? And how will this affect each and every one of us in our ability to live the gospel and thereby preach the gospel by the way that we act. How are we going to do that? You know, think again about our schools and places like that. Are they going to be able to continue to operate like this big, gigantic building? Or are we going to have to reimagine Catholic education to focus maybe on families and homeschooling cooperatives and things like that? What about our social services? Do we have to run big social service agencies that take government money? Or can we instead maybe follow the model of Dorothy Day and Mother Teresa and do our charitable work by the charity of our people, not by the work of the government? You know, we're going to have to think about it. And when I say we, I really mean you, right? You're the younger generation. This is your church for a lot longer than it's going to be mine. So it's going to be a challenge for people of your generation especially. I mean, people who work in public schools have a real problem with this. Are they going to be able to continue to work? Are people going to have to leave certain professions because of the challenge to their conscience? That they can't do certain things, they can't cooperate in certain things. You know, it's going to be a call to, well, I like to call it passive resistance, but it's really martyrdom. It's giving witness and maybe suffering. The COVID crisis, I think, has given us an opportunity to reimagine a lot of the way we do things. And I think if the Equality Act becomes law, it's going to force us also as a church to reimagine the way we do things. You know, we're going to have to fight in the interim. We're going to have to fight in legislatures. We're going to have to fight regulatory agencies. We're going to have to fight in court to defend our rights. Regular people are going to have to stand up and say, no, you're discriminating against me because of my religious beliefs, and file complaints with human rights commissions and the EEOC and places like that. Individuals are going to have to stand up against this. That's really, really hard. I know that. But it's a call to martyrdom, I think, and it's a call to witness. You know, it's going to be a real challenge. I think a lot of us are going to be able to ignore this for a long time. Keep quiet, you know, don't say those things, don't attend the training, right? Maybe don't wear the button. If you can get away with it, explain to people why if you have to. But it's not going to be easy. It's not at all going to be easy. It's going to be an ongoing fight. And the fight is not just the legal fight, but the fight is the truth fight. What is truth, Pilate said to Jesus, right? What is truth about the human person? We are made in the image and likeness of God. This is what we believe, what we have always believed. It is taught to us by revelation. It is confirmed to us by science and by human experience and human desire. Your theology of the body, I mean, this is love and responsibility, right? The whole thing is inspired by the theology of the body. That's the point of departure for the theology of the body, is this fundamental truth. You can't erase the truth from people's hearts. We can always appeal to that truth. We have to do it with love, of course, because there's a lot of people who are just clouded in their minds by ideology and by the falsehoods that are being taught by the culture. But we have to stand up for that truth. Our children rely on this. Everybody who's coming along in future generations, your children, your grandchildren, will require you and us to speak the truth about the human person and not to compromise on this. Yes, we love you. You have gender dysphoria. We love you. We will help you. But I will not lie. I will not believe a lie. I will not speak a lie. And I will not act on a lie. Alexander Solzhenitsyn, the great Soviet dissident, who I'm sure you've all heard of, you probably read his books in school, said, "Let the lie come into the world. Let it even triumph, but not through me." And that's something that we all, I think, are going to have to be saying more and more in the future. So, thank you very much. I hope I was timely. And I'm now open to questions, comments. I always say personal attacks. I'm open to that too. Can't say anything worse to me than my kids have said.
Not sure if I did this right. Okay, good. So one more round of applause for Ed Mechmann. Thank you, Ed. So we'll take about 15 minutes of questions, and Ed, when they ask the question, if you don't mind just repeating the question for the clubhouse people and people watching on Facebook. But actually, I'm going to start off with the question. And we're already starting to see this happening, but what's this going to really involve now with sports and bathrooms, and schools, and locker rooms, and all that stuff?
Yeah, that's an issue that has gotten actually most of the attention in the discussion about this issue has been bathrooms and sports. And I actually wanted to stay away from that today because I wanted to dig a little deeper into the other issues. But the thing that's really going to impact people is kids in their privacy, their bathrooms, their locker rooms, things like that. Schools and other institutions are not going to be able to exclude a transgender boy or transgender girl from whichever locker room it is that they want to use. You can't even set aside a single room for them because that's stigmatizing. So it's going to be an offense against privacy. And I think that gives us a great opportunity. It's tough on the kids, but I think it gives us a great opportunity to talk about modesty and privacy and how those are important issues. This is my naked body. I don't just show this to anybody. All right? There's a proper sense of privacy and modesty. And that can be violated by me forcing people to look at myself, right? If I streak down the street, or you forcing me to look at you. Privacy and modesty go both ways. So I think it's a great opportunity for us to talk, especially to our kids, about that particular virtue. It's also really important in that context, the school context, that we emphasize to our kids about bullying, right, and harassment, because that really does take place, and it is really hurtful to kids who are experiencing issues with their gender or their sexual orientation. Can't stand for that under any circumstances. So again, I think it's when somebody comes home in 3rd grade and says, oh, John now wants us to call him Mary, great opportunity for a parent to sit a kid down, tell them the truth about male and female, tell them, look, you got to treat John/Mary with love. Don't stand for you or anybody making fun of them or harassing them. Women's sports is a big problem, right? It's a big problem. Now, the number of transgender men is very tiny. I mean, it's less than 0.5% of the population, around 0.5% of the population. So it's not gonna be ubiquitous, right? You're not gonna have LeBron James all of a sudden show up at the WNBA game and expect to play. It's still gonna be a fairly rare experience. But it's gonna be something that is gonna be very hurtful to a lot of female athletes who will have no chance of competing against a male body. I mean, that's just not even scientifically doubtful. I saw something on, someone had done a study of all of the Olympic medalists, female medalists at the last Olympics in sports, track and field. And they compared those to the high school boys competing in those similar events. And in virtually every case, all of the boys, like the top 10 boys, were better than the best female Olympian. Okay, so, it's going to be very difficult for girls, very unfair for girls, I think. There's some lawsuits going through the system. There are some states that are trying to push back against this. New York is not one of them. New York requires trans athletes to play in the sport of their choice. It's going to be, you want girls to feel like second-class citizens, young girls who have trouble with their self-esteem already and their worth in society that treats them like garbage anyway. Just wait till this starts happening.
Thank you for your presentation. The way that you framed the whole discussion around religion, or how the Equality Act is going to endanger our religious freedom, it seems to me, and I don't know the whole history of a lot of what's led to this act, but it seems to me that really that's the main thing, is that there may be some good intentions of reducing bullying and discrimination, but in a sense, it seems like a direction mostly to crush the religious groups and their freedoms, and that we may not be able to get back from that. Do you agree with that, or do you think there's a different motive?
No, I do tend to agree with that. Most of the major employers in the United States have banned sexual orientation discrimination forever. Most of the major states have done so too. Large cities all have. Gender, of course, is a new thing, but still, I think most major corporations ban discrimination in hiring and so forth based on gender. A lot of states do, New York does, New York City does. There is still discrimination on the basis of sexual orientation, I think. It's hard for me, except in a religious context, to be honest, it's hard for me to see how that could be justifiable. In hiring most jobs, it doesn't make any, how could it make a difference? How could it be a bona fide occupational qualification that a person be heterosexual in most jobs? I can't conceive of it. So in many ways, the sexual orientation part of it is easy in a sense. I don't mean to minimize discrimination against gays, but it's easier, and it's mostly been taken care of. You look at the statistics from any human rights organization, the number of cases of sexual orientation discrimination is very, very low. Gender is even lower. Gender, of course, is a new problem. It has a lot to do with presentation and things like that. The case that went up to the Supreme Court last year was because a business didn't want a man dressed as a woman as their face to the public, receptionist. So that, I think, gender discrimination presents a little more difficult issues for businesses than sexual orientation does, because business presentation is really important. Even you're to fit the corporate image. In the old days, when I had a friend who was hired by IBM, short haircut, white tie, thin black, white shirt, thin black tie, the whole thing. No mustaches, no beards, right? This bill, I think, is largely motivated by a desire to squash religious objections to sexual orientation, gay marriage in particular, and gender. Some of the provisions, especially that one about it doesn't have to be the establishment doesn't have to be a building, it can be anybody. That's the wedding photographers. That's the florists. That's those people. So I really think a large part of the motivation of this, I think, is it's payback to a certain point for us opposing gay marriage for so long. I think it's a desire to stigmatize us as bigots. And a desire particularly to strike back against evangelical Christians who have been the most vocal in talking about individual rights. The Catholics mainly talk about our institutions. The evangelicals talk about individuals, and I think there's just a lot of hostility between the activists, not regular people. I think regular people don't have a lot of animosity towards each other. Activists have animosity towards a lot of evangelical Christians. So I think that's a lot of what's going on. And I bet if you put someone from the Equal Rights Campaign, which is the leading gay lobby group in the United States, I think if you put them up against the wall and really question them closely, I think they probably would admit it, that that's what they're aiming at. I think they're perfectly willing to be honest about it, I think, really. Yes, sorry.
So what does, the punishment look like for non-compliance? Obviously, you can get fired from our jobs or whatever, but can people get arrested? Will people go to jail? How does that work from a law perspective?
Yeah, these are not criminal statutes, so no one goes to jail, but they are civil statutes. And the civil statutes allow for private people to sue and for the government to sue. So it's very common for someone, for example, if they're fired and they believe they've been discriminated against, they go to the government, the EEOC, to try to get a complaint filed, and they sue you. There's a gigantic industry of lawyers who specialize in civil rights litigation. So you can have ruinous financial fines, you can have injunctions put against you, forcing you to do things. The cake maker out in, Colorado? When he was first sued under their state human rights law, they made him go to training, right? They made him go to a re-education camp, basically, and they put a monitor into his business to make sure that he obeyed the law. So it can make you say things, it can make you do things, they can fine the heck out of you, they can enjoin you. If you're working in a place, you absolutely can be fired, no question about it. In fact, you will almost certainly be fired if a complaint is even made, because no business wants to put up with a massive lawsuit on this. I can almost guarantee you'll be fired. So, pretty serious consequences. And the worst place in the world, I'm telling you, is to be on the other side of the V from the United States government. I used to be a federal prosecutor. It was terrible to be on the other side of me, right? If the EEOC is after you, it's a bad place to be. It's expensive to get a lawyer. They never give up. Never. So, it's bad.
Hello.
Hi.
First of all, thank you. I think it was a great presentation. First part of my question goes, how can there be a contradiction in terms of the Bill of Rights and there being like this freedom of religion itself, and yet a provision being passed by the House saying that, basically infringing upon religious rights, right? And then, just another question, just to hear on your opinion. How did we get here? How did we get here from this federalist ideas of rights and, this humanism up until now where it's like, well, we determine. How did this mess come about so quick?
Okay. The first question is a great question, and I didn't want to get too deep into the constitutional law, but I'll give you the quick explanation. In 1990, the United States Supreme Court, in a case called Smith versus Employment Division of Oregon, decided that you cannot invoke the free exercise clause, right? Congress shall make no law affecting the free exercise of religion. You can't use that clause as a defense against the application of a neutral law that applies to everybody. In that case, just as an example, that's a mouthful of legalese, right? In that case, the state had a law that you couldn't get unemployment benefits if you pissed positive for any kind of drug. Sorry for that. Tested positive for any kind of drug. Sorry about that. It applied to everybody. There were no exemptions, no exceptions. It didn't target religion. A couple of Native Americans used peyote in their religious rites. So they said, hey, wait a minute. You're violating my religious beliefs, my free exercise of religion, by denying me unemployment benefits, right? Because I tested positive for peyote. The Supreme Court said, tough luck. The law applies to everybody. You don't get an exemption. Maybe the legislature could give you an exemption, but they don't have to. So as long as the law is general and neutral, it applies to everybody without exceptions, you can't invoke the free exercise clause. Now that was a major change in the law. Before, the law gave us much more protection, and that's why they passed the Religious Freedom Restoration Act, to reestablish that higher standard of proof, that they have to have a compelling state interest. It has to be tailored very narrowly to address that. And if there are any exceptions for other reasons, you got to give it to the religious people. I don't know if you followed at all the litigation over the COVID lockdowns, but our beloved governor lost a big case in the Supreme Court because he imposed regulations on us, Diocese of Brooklyn, and Orthodox Jews that were stricter than the ones he gave to, acupuncture studios and other places like that, gyms and restaurants. And the Supreme Court said, hey, that's not a neutral law because you treated religion worse than you treated them. So if they treat us equally, we're stuck. If they treat us unequally, now we can fight them. The problem with the Equality Act is it treats everybody equally. So we can't use the Free Exercise Clause. We would have had to use the Religious Freedom Restoration Act, but it won't let us. So what do we got? Bupkas, as my mother-in-law would say, nothing. We lose, okay? So that's the first question. Second question, how do we get here? Wow. Some people say that this is the inevitable endgame of the philosophical concept of liberalism. Liberalism being the idea that people should be free to make decisions and define their lives without any interference from government and without any interference from divine revealed religions. That's basically liberalism. That's very airy-fairy. I think we really got here because of abortion. We got here because of abortion. Because to legalize abortion, the Supreme Court had to invent an almost unlimitable personal privacy freedom. That's what they did in Roe v. Wade and the following cases. And in order to get that, they created this little monster in the law that swallows everything. Can swallow everything, doesn't necessarily. That's how we got gay marriage. It was specifically based on that. It's something that just, this idea of untrammeled freedom, that I have to have the freedom to define my life, my universe, the meaning of life, all this kind of stuff. That's actually almost a quote from a Supreme Court opinion, by the way. How do you regulate something that someone says is essential to their meaning of life? And under the Supreme Court law, you can't. So it was an endorsement of this theory of radical autonomy. And they did it to legalize abortion. I don't think they realized the significance of what they were doing, but this is the inevitable legal result. Culturally, it's the sexual revolution. It's totally the sexual revolution. Separating sex from marriage, separating sex from procreation, separating, well, it's just about having fun with whoever the heck you want, right? So it's the sexual, those two things running in parallel tracks, that's, I think, what did it.
I couldn't have thought of a better, or had a better, like, introduction to my question. So
Great.
it's-
You gonna read something?
Okay, so this seems like the logical, like you said, it seems like a logical end of liberalism and utilitarianism and emotivism. So it's kind of a two-parter. In law, it seems, right, it makes sense that the exceptional case always works its way in and kind of gains a spotlight. Such as the case with like transsexual, et cetera, that's kind of brought us to the public square. And so then there must be like a broad attempt to define niche categories, which is the left likes to do in terms of just like I think we started out with, recognizing somebody as gay, and that turns into LGBTQIA, and so on and so forth, at the expense of, as an attempt to include everybody, we start to, or in the attempt to define everybody and be inclusive, we start to be exclusive in our definitions. Bummer, I guess. So I don't know, maybe a comment on that. But my actual question is, if this is the logical end of emotivism and utilitarianism, and this is actually the fight is taking place on the stage of the Equality Act. Who are the public figures that are like speaking out? Who's kind of taking a stance? Because the common citizen probably can't. Is academia pursuing this? Is there a place in the public square, like, having this conversation? Are universities fighting back? Probably not, but is there anybody at that level kind of moving the senators so I just, in one final note, I think that, pluralism has got to be respected. But how if one side has the benefit and the advantage of mass emotion, the other doesn't, then how does the other kind of stand up and have a proper and fair and equally heard rebuttal?
Yeah. The way the law develops is it's a funny thing. Traditionally, when the United States was founded, for example, there was a notion of natural law where every lawyer, every founding father believed that the validity of the civil law, the laws that we have on the books, are dependent on them being equivalent to or compatible with divine law. Right? That's one theory of natural law, that there is a law that comes to us from God, it's written in nature, and we enact it in civil law. Under a natural law theory, this kind of stuff would be impossible to imagine. Abortion would be impossible to imagine. Unfortunately, thanks to positivism and utilitarianism and all those things you mentioned, that view of the law has fallen apart. When I went to law school, I went to Harvard Law School back in the 80s, and my professors laughed at the idea of natural law. I gave a talk one time to a group of Catholic lawyers, and they said, natural law? I thought we got rid of that a long time ago. Okay, show me the bill that repealed natural law. I'd like to see that. Law, unfortunately, to a great extent, has become captive to an approach. It's really a critical studies approach. I don't know how many of you are familiar with that, where it really is a question of structures of power. This is how most lawyers are taught now, and how most lawyers think. It's a question of power and getting power to exert your will over other people. The big problem with emotivism is when you give them power. This is what happens. The Equality Act is what happens. We're not talking about tolerance anymore. We used to talk about tolerance in the old days. If only we could talk about tolerance now. We're not. We're talking about requiring submission. And that's what happens when you look at the law only through the lens of power. The law is power, but it should be power exercised to the right and to the good. That's the theory of natural law. So, who's fighting against this? I don't know if that helps, but that's, you got to also remember too the way lawyers think, just pragmatically. Lawyers think in terms of boxes, okay? And the law is a box, and I try to fit my case into the box because I need to win this case, right? So I'll try to fit my law. If my case doesn't fit the box, what do? I grow the box. I convince the judge to grow the box. So that's where the hard cases come in. The hard cases grow the box, and now my case fits in. So the next guy comes along and he says, wait a minute, I should fit in there too. You just need to grow the box a little bit more. And that's the way it happens. That's us, lawyers are basically plumbers, but we use words instead of pipes. That's just what we do. Who's fighting this? There is actually a large body of conservative legal scholars, and it's hard to use the word conservative anymore because I don't know what the heck it means in the post-Donald Trump era. But conservative legal scholars tend to be what's called originalists. They want to go back to the original meaning of the Constitution. Or textualists. They want to interpret things based on the actual text and what it means. They tend to be good sources of resistance to this kind of stuff because none of this stuff fits into original meaning of the Constitution or the word sex. I mean, the Supreme Court decision last year where Justice Gorsuch said sex means sexual orientation. I can't even think about it. It makes my brain hurt. It's so bizarre. So there is a good body of conservative lawyers. They tend to be focused around groups like the Federalist Society, the Hoover Institute, the Libertarians all go over to the Cato Institute, things like that. Conservatism is very fractured right now, and the Libertarians really don't care that much about these social issues. The evangelicals, they're very ardent about these issues, but I think sometimes they're a little too ardent and they shoot themselves in the foot, as many of them did on January 6th and over the results of the election. Our bishops have a problem here. Our bishops are very much on board with this. The Catholic churches, the Catholic conferences are fighting this. The bishops have almost no credibility in the public square right now. I think that's fair to say, at least my experience. So we've really been relying on a sort of a remnant of the Republican Party and a wing of conservatism that still holds to some of the social values and still holds to some of the old values of let's interpret the Constitution according to its original meaning, let's not expand individual rights too far, let's let people live, people should live as they want to live, and that includes us. So that's who it is. The opposition is much more unified, they're much stronger, they control the universities, they control the law schools. It's an uphill battle. Does that help at all? Yeah, I know. Whenever I talk at meetings, I'm like, the bad news bears here. It's like, oh, God, he's going to talk again?
Did natural law ever stand a chance in American,
Really until, I would say, the 1850s or 60s, natural law, 1850s, I would say, natural law still held sway. Natural law was killed in the United States because of slavery. Slavery killed natural law. When Justice Wilson, James Wilson, one of the great legal thinkers of our history, in I think it was 1802, gave lectures about the law. He talked about God's law, he talked about man's law. He was held up, he was a Supreme Court judge. Everybody agreed with him. Justice Story wrote a history of the Constitution, talked about natural law. Everybody agreed with him. When William Seward stood up in the United States Senate on a debate about slavery, I think it was 1857, and talked about a higher law, he was denounced and vilified all across the country. When Lincoln gave his Lincoln-Douglas addresses, he didn't win that election. Stephen Douglas, who was preaching power and positivism, the law is just what the powerful people say it is, he won, not Lincoln, the natural lawyer. So it was slavery that killed him. Just like abortion killed other things, slavery. It's one of the horrible legacies of slavery. Corrupted our law. Corrupted everything, but it corrupted the law. Sorry, I keep on mentioning these things like from your ancient history class. I'm sorry, it's just one of those things I love history.
This is just something I was thinking about, and it's not to say that I necessarily agree with it, or I don't want my religious freedoms to be protected, or to even think of the Sisters of Life being forced to do anything like you described. But I'm just wondering, if we protect religious freedom, individual religious freedoms very strongly, do you think there's a chance of it going too far? Where, for instance, I think of situations like this. Recently the guy that we all saw in the news who kind of stormed the Capitol wearing that.
Oh, with the horns, yeah.
The horns, where he goes to federal prison and then uses basically an internet name where someone called him a shaman to claim that he's now a shamanic practitioner, and his religious beliefs mean that he needs to eat special food in jail and things like that. And I just, it's a small example, but where this wouldn't be taken too far, where like you mentioned that people can use laws to sort of attack each other. Do you think that anyone would start to do that and maybe try to delegitimize religious freedoms that are genuinely from the tenets of our Catholic teachings and things like that?
Yeah, that's a very serious danger. Actually, the guy with the horns won his case to get his vegan diet, just like the Muslim won his case in the Supreme Court to wear his quarter-inch beard that the prison didn't want to let him win. And the Muslim girl won her headscarf case against Abercrombie. That's what we're accused of, in fact. We're accused of using religious freedom as a justification to discriminate and as an expression of bigotry. And I really do worry, particularly about the individual cases, not so much the institutional cases. The institutional cases, I think, are easier to limit because, like a school, it's got to have a mission statement, it's got to be living its mission. That's more of a defensive thing. It's not going out into the public, although you do sometimes have clashes with teachers and students. But I think those are easier for people to get, Why are you making the Catholic school do this? The problem with the individual cases is that a lot of those people are engaged in commerce. They're engaged in commerce with everybody in the world. They'll take anybody. I'm thinking like the cake maker, for example. But I won't take you. And I think a lot of people are uncomfortable with that because it's one-on-one, first of all. It's me right in your face. And the idea of offending dignity is a big deal in supporting these cases. Dignitarian harm, hurting my feelings, basically. One-on-one, those cases are much harder to justify, to be honest. I have a hard time justifying a lot of those cases. The photographers, I think, for example, photographers, that's an expressive art. You're saying something with your photography, I think. Okay, the florist? The limo driver? The cake maker? I get a birthday cake for my kids from Carvel down the block. Happy birthday, Luke. Is Carvel saying happy birthday to Luke? Or are they just writing on the cake what I asked them to write? I think a lot of people think that way too. And so the danger is that you push those cases too far and it delegitimizes our argument. I'm absolutely convinced that provision in the Equality Act about the revoking the Religious Freedom Restoration Act for us is because of the Hobby Lobby case, which was the contraception mandate case that the Supreme Court upheld the Christian businesses a right to say no to contraception in their health insurance. and the wedding cases. I think it's a direct reflection against that. So, yeah, it's a serious, serious problem. And I also, I also worry about the rhetoric that goes along with those, especially on the gender things. There's a lot of very, very unchristian rhetoric that goes on in gender cases. Not so much on the gay and lesbian cases, because we're used to speaking sort of normally about gay and lesbian people. We don't. It's not as much there, but with the gender cases, it's very tough. You hear people say it's a mental illness. You people are sick. You're crazy. That doesn't help. That really doesn't help. Before the vote on the gay marriage bill, I know, Colin, you want to cut me off here, but I will say one last story. Before the vote here in New York State on the gay marriage bill, I was giving a talk to a group of our people who were contacting the legislatures and so forth, and some really ugly things were said at the meeting. And I stood up and I said, look, let me tell you something. I would rather lose than win with that kind of talk. Right? I would rather lose. Because hatred always loses, even if we lose the legal battle. If our hearts are filled with hate, then that kills us. It does nothing to them. It kills us. So that's a real danger in these cases, especially when they get really hot and contested. And when people really feel that they're being oppressed. A lot of our Christian friends, a lot of our evangelical friends really feel that they are being targeted and oppressed. It's arguable, but they feel that way. And sometimes the snapback reaction is very counterproductive. So, does that help?
All right, I thank you very much again for coming tonight and giving that talk. So, a round of applause. Just finish with a prayer. In the name of the Father, the Son, and Holy Spirit. Amen. Hail Mary. Full of grace, the Lord is with thee. Blessed art thou among women, and blessed is the fruit of thy womb, Jesus. Holy Mary, Mother of God, pray for us sinners, now and at the hour of our death. Amen. And the Father, and the Son, and the Holy Spirit. Amen. And the church was nice enough to stay open for us. So if we could start, we try not to read around too long.